I have no idea if this is gonna work this time. I've recorded this in part probably about 7 or 8 times. I've had PC crashes. I think OBS doesn't like my computer. I've had fire alarms go off. I've had dogs go on rampages. Anyway, this is a Bunny Boots stream. SNC Strategic Non-Compliance 0.11. Let us talk about military bases. This gentleman, James Freeman, was arrested outside of Fort Huachuca, I believe it's called, in Arizona. From where I'm sitting, I don't think his criminal charges stand up. But I don't know, because you never know which way the court's gonna flop on it. So I was watching the stream and I found Bunny Boots saying ridiculous things. I am somewhat more prone to judge Bunny Boots because he has stated that he wants to be a lawyer, and he holds himself out to be a First Amendment guy, and he reads these cases online. So if he's going to be making legal judgments, I'm going to judge him for that, as opposed to just the random dude who says, "Dirt, you should sue." So without any further ado, let's make sure that we're going to be going on 2 times speed because this is long. And let's get into it.
I'm sure everybody saw I was not arrested yesterday at Fort Huachuca. I was detained. I was detained for officer safety. You guys heard that?
Okay, if that is the case with him, if he was removed from that location, that is a de facto arrest. That has been upheld in the courts. When you move, in fact, that goes outside the bounds of a Terry stop. A Terry stop pretty much means you have to be held on the spot. And skip 30 seconds. It might be. I'll turn it up a little bit more on.
Terry does not hold that you have to be held on the spot. Terry doesn't hold anything about moving the suspect or the detainee. So I don't know why you're saying that. Terry holds that an officer needs reasonable suspicion of a crime for detention. And the officer needs reasonable suspicion the suspect is armed for a frisk. The penalty, if there is any such thing, of lacking reasonable suspicion for the detainment and or for the frisk is that any evidence that the officer finds as a result of said detainment or frisk is not admissible in court. It doesn't mean you get to sue the officer. It doesn't mean anything like that. It just means that that evidence isn't admissible. In the case, Terry v. Ohio, Terry was stopped because the officer suspected that he was casing the store to do a strong-armed robbery. He was charged with some sort of a weapons, illegal possession of a firearm or something like that, because when the officer searched him, patted him down, he found the firearm. Terry's goal was to suppress the firearm as a result of an illegal search. The court held that the search wasn't illegal. So you could see that if Terry got what he wanted, that the officer needed probable cause to do the pat down, then the result of that wouldn't be that Terry would get some sort of a monetary reward, but it would be that the evidence, the firearm, would be suppressed. If the prosecutor didn't have access to the evidence, to the firearm, if he couldn't present the firearm in court, it would be impossible, or some reasonably close facsimile to impossible, to get a conviction for an illegal firearms possession.
Here, so this way, maybe it's probably from his mic.
In the
Yeah,
live stream before they shut it off. I was never, ever actually arrested yesterday. I was detained for somewhere between 3 and 4 hours by military police. They pulled me off of public property, kidnapped me, put me in one of their cars, and took me onto the base.
That is a de facto arrest right there. He was arrested. It wasn't a detention. He has a straight up civil case against Fort Huachuca because of that.
under what theory of recovery does he have a straight up case against Fort Huachuca? In order to sue the federal government, which Fort Huachuca would be the federal government, you have to have, Congress has to give you the right to sue, because that whole sovereign immunity thing, if Congress hasn't given you a right to sue, then you can't sue Fort Huachuca. I'm not aware of any cause of action that this has brought up, and of the close but no cigar causes of actions I could think of off the top of my head, they get extinguished if he gets convicted of any of the, not charges, but of any of the crimes he was cited for. So saying that he was arrested isn't a magic bullet. That doesn't mean anything. And it's just, for example, just think about all the people who are arrested and found not guilty. They don't automatically get to sue for the arrest. It's the government, the state governments, federal governments, local governments, whatever, they have some leeway. They get to make mistakes in who they arrest. It's only if they grossly violate your crimes or violate your rights, like if they beat you or use force that is unnecessary, then maybe you can recover at that point. But there's nothing in there that says just because you were arrested that your rights were violated.
Put me in one of their cells, patted me down, groped me really good, it felt nice, and then put me in a cell. Processed me as if I was being arrested and booked. Fingerprints, DNA swabs.
Yep, that is a de facto arrest. That was no detention. James Freeman, if you hit
it wasn't a de facto arrest because he was cited in lieu of arrest. So it's slicing hairs that don't really need to be sliced. But you're making a point out of something that it doesn't lead anywhere. He was cited, so slow your roll on that, buddy.
Yep, seeing this, and I'm gonna make sure to tag this in the metadata for the YouTube archive. James Freeman arrest. How to go there? Yeah. Or I'm probably overthinking it, but that is an arrest. That is a clear arrest. The fact that they removed you from that spot, they took your fingerprints, they put you in a jail cell. Yeah, you were arrested. The courts will look at that. That is arrest. And a lawyer will look at that. That is a clear arrest. It was no detention.
The funny thing here is the lawyer's looking at it and saying, well, kind is, kind isn't. So that should tell you something. One of the things he was cited for was failure to ID. The DNA swab and the fingerprints may be related to him failing to ID. So, it's...
The cops that are there, the security personnel, you fucked up. You straight up fucked up. That's the...
Is that a legal determination that they fucked up? Or is that just your hope, your opinion?
Deal with that. As is, he was completely legal within his actions. And yeah, he's got to...
That's another legal determination that you don't know. Was he legal in his actions? I'm a lawyer. I don't know. I mean, you gotta... I suppose I could watch his whole video and try to figure out where property lines are and everything. But I mean, it's going to come down to what the finder of fact determines. If it's the judge in a bench trial or a jury, they're going to determine what this guy did and whether or not it fits the required elements for whatever crime he's been charged with. And until that happens, we don't know. We just don't know. I would have told you O.J. Simpson was guilty, but a jury found him to be not guilty. You just don't know. You don't know until it goes to court.
He's got a pretty good beard, just like mine. His is straight, though. His is straight, not curly. Mine's all curly and sort of a nice little fro kind of thing that's got going on. But yeah, as is, he was de facto arrested. because he was removed from that location. The same thing happened in News Now.
Being removed from a location doesn't turn a detainment into an arrest. Just, the court's going to look for the totality of factors in a situation to figure out whether or not you're arrested. Typically where it comes into play, whether or not you were arrested, is where you confess or something like that, where if you're arrested, your Miranda rights kick in. Before you're arrested, you don't have those Miranda rights. You don't have the right to an attorney if you're not under arrest. You don't have the Miranda portion of the right to remain silent. So under Miranda, if you don't waive your Miranda rights and you refuse to speak to them, they've got to kind of accept that. If you demand your lawyer, they've got to kind of accept that. There's little weird tricks where, like, if they wait enough time or whatever, then all of a sudden they get another go at you or what. There's weird little things, but generally speaking, if you say, hey, I don't want to talk to you, they kind of have to. Okay, well, he doesn't want to talk to us. We got to, like, stop. So where the differentiation between arrest and detainment usually play out is in that kind of field, where in a lot of the cases you study in, like, law school and things like that, it's, Joe Blow, the police show up at Joe Blow's door and they're like, hey, can you come down to the police station? We just want to talk to you. And Joe Blow's like, yeah, okay. And then they go down to the police station. They talk to him for, a while. And then he was like, hey, man, can I go get a cigarette? And, they take him out onto the roof and they let him smoke his cigarette. And, they're just jibber jabbering. And then they bring him back down to the same place and they start talking to him again. And then he ends up confessing and they arrest him. Where that whole was he arrested or not comes into play is in that, well, did he feel like he was free to go? Did he feel like he was under arrest? And the reason why they're asking that, because you can't coerce a confession out of people. And the whole point of Miranda is to keep people from feeling like they're coerced. That's why it doesn't apply before you're arrested. So him just going all, BBI just going all crazy about, oh, you were arrested, it doesn't really matter in this situation. Like, yeah, if James Freeman, I think is his name, if he confessed to committing a crime while they were saying he's not under arrest, then sure, yeah, absolutely. A defense attorney would be like, yeah, I'm going to try to suppress that. I'm going to try to not have that affect my client because he was in a coercive situation. He had been taken to the police station. He'd been fingerprinted, been treated as though he was under arrest. He felt like he was under arrest. He should have had access to an attorney at that point. He should have had the right to not be hassled and remain silent. Because, like, with Miranda, you could be like, hey, I don't want to talk to you. And then they can't talk to you. Whereas, like, if you're just out on the street and you're like, hey, I don't want to talk to you, they could be like, well, come on, man. And they could keep asking you questions. That's the difference. So just because he was arrested doesn't really change anything.
Houston, when he was filming the police station, and the cop placed him in cuffs, took him inside, and then read the law to him on the identity thing. And obviously, a lot of us are familiar with that with that specific outcome. He was cut and let go real quickly after the police chief learned about it.
So the outcome in one situation doesn't mean that there is precedent. The police chief may have released him because he didn't want the political ramifications of it, because maybe he respected News Now Houston and just didn't want to, mess with the guy. Maybe thought his guys were just being jerks for no reason. We don't know. Like, if you get pulled over for speeding and the cop gives you a warning, that doesn't mean all of a sudden that speeding is no longer a thing. It just means that cop decided not to prosecute or not to give you a speeding ticket. Cops obviously can't prosecute you, but whatever.
I mean, let's see, the reason I wasn't arrested is because I asked repeatedly. Oh, hey, James, I didn't know you're in here. I wasn't arrested because I asked for police arrest. No, James, it is an arrest. You know what, James? Do you want to get in on this? Do you want to hop into the voice chat? Because if you can get into the Discord and learn how to operate, I have no problem talking with you on the live stream here. But James, just because they say it's not an arrest doesn't mean it's not an arrest. That was an arrest. They removed you from the location. What they say has no regard in that. The courts will still look at it and go, you removed him from the place, you took him to the jail cell, you processed him. That's an arrest. That is a de facto arrest, man. And I'm glad you're out, man.
And a lot of these things, context matters. Like, what are they looking at? Why are they looking at it? What is the defense trying to prove? What is the prosecution trying to prove? Just because he was arrested doesn't, in this situation, I don't know where you're going with it. I don't think it changes anything, because he ended up receiving citations, and those are typically called citations in lieu of arrest. And what they do is essentially it's the same thing as being arrested. They give you a ticket so that you're going to show up at a future court date where the prosecutor may or may not decide to press charges. But the only difference is, if they arrested you instead of giving you the little citation, you'd have just stayed in jail overnight, and then the prosecutor would have decided whether or not to charge you. So it's 6 of one, half a dozen of the other. It doesn't really change anything.
But the detainment, taking you out to the facility for officer safety, does not count. It violates Terry v. Ohio, something that applies to them clearly, because that is a SCOTUS case law.
Violates Terry v. Ohio. Terry v. Ohio didn't deal with moving suspects, moving detainees. You can move people you've detained. There's no law regarding that. For example, oftentimes you'll see the police place a detainee in the back of a patrol car and then drive him around the block so that a witness can look at the suspect, surreptitiously typically, and say, yeah, that guy matches the description of the guy who stole my purse or whatever. Cops move detainees all the time, like they arrest somebody or they detain someone in the middle of the street and they'll pull them off onto the sidewalk to talk to them. They'll place them back into the back of their patrol car while they're waiting to do whatever. They'll pull a car over, detaining the people in that car. They'll pull them out of the car and have them sit on the curb. Police move detainees all the time, and the courts don't say, oh, well, all of a sudden this magic thing happened where you moved the detainee, now they're arrested. The distinction is you need probable cause to arrest somebody, but the courts really, they give you a lot of leeway. I've seen court cases where you've got, like, after you pull someone over, you've got, 15 to 20 minutes or something like that to kind of do your thing, and that's reasonable. But the courts are still going to look at all the factors in the case to determine whether or not it was reasonable for the police to do whatever action they did. So it's not just because they moved him doesn't mean they, in air quotes, violated Terry v. Ohio. And again, you can't violate Terry v. Ohio. I don't know if I've said this before in this particular recording, but Terry v. Ohio specifically deals with suppressing evidence that came about through an officer's reasonable suspicion that crime was afoot, that allowed the detainment, and a reasonable suspicion that the suspect was armed, which allows the frisk. That's it. That's what Terry deals with. If the cop doesn't have reasonable suspicion, then the evidence is suppressed. That's it.
Hey, Mike, the film, and does it sit in the lip over there? Yeah, as is, Mike's out. Apparently, immediate family member had a heart attack, and he's been out with that. So we'll hopefully be a little bit more in shape for next Friday there. But yeah, this is a clear arrest, a straight up violation of your rights kind of thing. But while I wait for your reply,
it's not a straight up violation of his rights.
I'm gonna go ahead and continue playing at least part of your live stream here.
All kinds of stuff. and then cited me with 3 citations. One was something along the lines of entering a federal facility with the intent to commit a crime.
I just want to stop at this point to note that he was cited with 3 citations. Citations in lieu of arrest. That means that instead of arresting him, they gave him citations. It's 6 of one, half a dozen of the other. He just didn't have to spend the night in jail. That's really all. That's the difference between the two.
The other was failure to ID, and the other was photographing a federal facility. So,
Okay, well, chances are, if the third one there is what I think it is, it does not apply to that damn situation.
If the third one is what you think it is, it probably is. I mean, I don't know. I haven't seen what he was charged with, but just remember that you're hypothesizing. You don't know.
Driving, so I'll listen in. Just be educated by you here. Thank you. Okay. All right, James. Yeah, stay safe while driving. Try not to engage too much on the chat and all that stuff. I don't want people crashing because
You really shouldn't be educating people on the law, especially since you don't know what you're talking about, bro.
they're trying to text or pay attention to the chat while driving and all that stuff. But here's the deal with this. This is where the cops really screwed the pooch. Even if he was standing a little bit on the federal property, if I remember correctly, it was United States v. Appel. We'll look that up here in a few minutes. That actually caused the whole blue or red line that's done on the street line, on the pavement there for the road that goes into the military bases. That will pretty much signify the limit of where they can act a trespass right there. And that was a case that actually follows up with the Flowers case.
He goes into Appel a lot more later in a part where he's covering something that News Now Houston did, and I'm not going to go over that particularly much. But here's his link. This is US v. Appel. It doesn't say, I don't think it says what he thinks it says. They basically upheld the right of the military to control the base, even the parts where they've granted access. In this case, it's Vandenberg Air Force Base. The state of California has easements granted for a highway running through it and a couple roads. And the court held that the commander has control over that as far as trespassing people, which that's kind of weird, but whatever. There's also a peaceful protest area outside of one of the main gates. That the court held that the Appel could be trespassed from that area. So this is his link. You saw I clicked on it from here. It's scotusblog.com. It's this one. It was decided in 2013 or 2014. I think it was decided in 2014. Yeah, February 26, 2014 it was decided. So it's, or March 31st, something. I don't know. Anyway, so they reversed and remanded. What they were reversing and remanding was the Ninth Circuit Appellate Court. Ninth Circuit is the right court for this, but they reversed the Ninth Circuit Appellate Court's determination that the military didn't have exclusive control over the area, and so therefore they couldn't trespass Appel from it. So yeah, here we go. We're going to go ahead and click on this. I have no idea where we're going. Bloomberg Law. I've never been here before. Bloomberg? I never even knew Bloomberg did law. Anyway, so concurring opinion. No, this is Robert's opinion. This is unanimous opinion. So yeah, Vandenberg Air Force Base, closed base. He was barred from the base for trespassing. He threw like pig's blood or something on a sign. He continued to enter the protest area. The magistrate judge convicted him of violating 18 U.S.C. 1382. This is a federal trespassing statute. I don't have a sign-in for this. Stop it. highlight, and we're going to search. Here we go. So yeah, 18 USC is criminal codes. Entering military, naval, or Coast Guard property. Whoever goes on any military base, blah, 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 shall be fined or imprisoned not more than 6 months or both. Yeah, so it's basically a trespassing statute. It's a federal trespassing statute. What they're holding was, this is in the syllabus. You could read the decision, obviously. It just restates what's in the syllabus. But the quick deal is that contrary to Appel's argument, 1382 doesn't require exclusive possession and control, and Section 1382 applies to any place with a defined boundary that's under the command of a military officer. So I don't think this is going to go the way that Bunny Boots thinks it's going to go. If the area out in front of that gate is under the command of that military officer, of the base commander, then yeah. But the trespass law, so if you go on it for a purpose prohibited by law or federal regulation, so they would have to prove that he was there. So this, okay. So this is that first charge that he was brought up under. It sounded like a burglary statute to me when I was listening to it. So this is the law. He entered onto the base for the purpose of committing a criminal act. Yeah. So it's just trespassing / burglary rolled into one. So yeah, Appel doesn't say what Bunny Boots thinks it says. So yeah, so all they have to show, all the prosecutor would have to show, is that his intention on entering that jurisdiction was to break a law or a lawful regulation. And yes, they are different. Savor the difference between those two, because it'll come up later. There's laws and there are lawful regulations. Laws are different than regulations. Keep that in mind, because Bunny Boots is just going to poop all over that.
The second, entering, well, let's see. Let's review the charges again, just to make sure I get this right.
Entering a federal facility with the intent to commit a crime.
Entering a military, naval, or Coast Guard reservation for any purpose prohibited by law. I think this is what this fits it. It's obviously stated differently, but this sounds like what he was charged with.
Yeah, that's just a throw-on. That's a resisting arrest kind of charge right there. That's just a...
That's not a throw-on. That's an actual charge. They have to prove. So the elements of this would be that he went upon the base, he entered, and his intent was to commit a crime or to violate a regulation. Wow. Yeah, so like burglary, for example. Burglary, common law, is the breaking and entering into the dwelling of another at night with the intent to commit a felony therein. That's like that's what you'll memorize. You go to law school, you'll memorize that. It'll be just beat into your head by your criminal law professor. And each one of those things is an element. Breaking. So like breaking would be like, it's been moved down to like just moving an open window ever so slightly more open so you can get in. That's now breaking. But it used to be where you actually have to like break the lock or pick the lock or force the door, something like that. Entering would be you or a tool or something like that. Like if you try to like use a fishing pole to fish something out of somebody's house, that would be entering. But basically you have to break the plane. So a part of your body has to go into the building. It had to be the dwelling place. Literally had to be someone's home of another at night. It literally had to be at night. And then for the purpose of committing a felony therein. So you had to go in there intending to burn it down or kill somebody or steal something, etc. Most states have changed a lot of those things, but that was the common law definition. Now, you didn't have to actually complete whatever felony you were trying to commit for the burglary charge to stick. All you had to do was break and enter, and then all of a sudden with the requisite intent, and then that's burglary. You didn't have to even start trying to light a match to burn the place down. You broke in there with the intent to burn it down. That's burglary done and done. Maybe there's problems trying to prove that, but assuming that we're omniscient and we know your intent, if we know your intent and you broke and entered, done. So it's not an add-on charge at all. This is pretty clear, unless some case law that I'm not aware of has modified it. If he's entered it with the intent to commit a crime, that's done.
To throw on to say, hey, we're going to be, okay, let's see, sorry for leaving you around. I posted 21 hours ago. Search the word amazing and you'll get to...
Add-on charges like the contempt of cop charges, like resisting arrest. If you're not being lawfully arrested, they can't get you for resisting arrest. Unless they've made a statute that says that you can't resist arrest, even if it's an unlawful arrest. But, I'm just talking common law kind of things now. A lot of times, if it's like a borderline case, resisting arrest where you didn't actually hurt anybody or really do anything, like the people who go limp, that's actually resisting arrest. Like if they're trying to arrest you and you just, wet noodle it down onto the ground and you don't help them out at all, then they could actually charge you in some states, #not all, for resisting arrest. If what you're being arrested for gets tossed out, typically that'll get tossed out too. Now, if you grab an officer's gun and you shoot him resisting arrest, and then the underlying charge is dismissed, that resisting arrest isn't going away.
Okay, got it. I'll look at the DOQ. I'll go ahead and look at it. It was large discussing legalities around photographic. Okay, got it. I think I know what it is. I'm only using the talk to checks for soft chat words. Okay, got it, James Freeman. You're being smart with that stuff. Just stay safe. But when it comes down to this specific issue, what they did there was the throwdown. What intent was? The thing is when they sat there and processed him all like that, that was a de facto arrest. And then they cited him with that stuff. That was a de facto arrest. It was an arrest in the aspect that, okay, we're going to arrest you.
There were citations in lieu of arrest.
We're going to give you this stuff, cut you loose, get the fuck out of here. That's what they did. It was an arrest. It was not a detention. It's not a detainment, because a detainment happens on the spot. When I had Department of Homeland Security pull up on me when I was filming the FBI building for dealing with the federal courthouse / visitor center up there in Anchorage, that's going on 4 years ago. With that specific situation, that was a detainment when he came up. If I wasn't allowed to go, he wanted my ID, he handed me citations. That is a proper detainment in that aspect. Now, what they did with James Freeman here, that was an arrest. That goes outside the bounds of a Terry stop.
Again, he's reading in some "you can't move him" thing into detainment. I'm not sure exactly where he's getting that from, but citation needed.
So James can hear, please tell him how much I have respect for how he handled himself. That was from Shadowboxer, James Freeman's. And yeah, you did yourself well. And I love how you did your silent treatment. Well, silent treatment turning into a minimal speak situation. But you did a really good job. You handled yourself greatly with that silent treatment, just from the amount I've listened to. And as I said, I can see more people there get involved, trying out the silent treatment. It's not for everybody. It's not for every single case. It's a double-edged sword. It can hurt you. It can help you. It's just another tool in the toolbox, a specialty tool.
The other was failure to ID.
Failure to ID. Well, that's because, those two charges alone right there, the failure ID and the other one, the arrest was completely illegal in the first place.
Again, you're making an assumption there. The arrest was completely illegal. I don't know that it was. And you'd have to look at Arizona statutes. I haven't looked it up. You didn't provide a link to it. And I'm trying to work off of your stuff here without going too far, because I'm kind of making a point that, you had all the tools there. You just didn't read what you had. So, cat's out of the bag there. But yeah, I don't know exactly what Arizona's ID statutes are, but they may require you to ID on detainment on reasonable suspicion. And then if he didn't do it, even if they didn't have probable cause to arrest, then that would still be a crime. I don't know, because you didn't link it, but you probably don't know either, so you might want to think about that.
And of course the other charge. But let's go ahead.
And the other was...
And let me double check right here and see if there's anything else before I backtrack to the other one 21 hours ago. So we're going to backtrack to the other one and look for this thing here. The other chats, or the other conversation. Let's see. Oh, and Appel is based off of Flower v. United States, which was...
Yeah, so we're going to jump a little bit. His study of Appel, I've already kind of gone over it. We're going to 44 minutes and 20 seconds, or thereabouts. We'll go to 44 minutes, 21 seconds.
Installation equipment, even in a soldier's uniform wearing equipment, in violation of federal law, does not matter location. Okay, this is quite the, here. Enforcement. It's been made, let's see. I'm gonna start over. I'm reluctant to inform you this is a public forum because law enforcement has seen and made arrests later based on the statute of limitations, is 5 years in this case. I think I should have a wrench. Fleeing. Well, why Shadowboxer, you got a link or something like that? Here, I'll just go ahead. You know, if you start abusing your moderator powers, you're going to end up with a ban. I'm going to just let you know that. Remember, my policy goes generally unmoderated unless there's something really illegal or something against terms of service. The prosecution has up to 5 years, and they have a few YouTube cases, including one in Louisiana, brought numerous felony charges. Law enforcement may also seize all equipment until such time the charge is brought, the expiration of statute of limitations, or court orders release. 2017 is a record year for YouTubers going to prison or becoming a fugitive of justice after a conviction, becoming sentencing, being shot by cops or shot and killed by cops. Yeah, I'm gonna need a citation for that one. Where the hell did you get that number? I have bunny slippers. Nice.
I just find it hilarious he's asking this guy for a citation when he hasn't provided citations for most of his claims.
Let's see here. This military... Yeah, I already read that comment there. Michigan also is a state where a YouTuber was shot and killed by a cop. 18 photographed the fence. Okay. Here is the deal with this charge right here. This does not apply to that situation. There has to be proper signage. There has to be an order for this.
Has to be proper signage is what he's claiming. And it has to be an order for it. Well, lucky for us, he provides us with a link. It's going to be 18 USC 795. But this is still fun. Let's listen to it.
Okay, let's pull this one up. We'll read through this. 18 USC, US Code, well, CFR 790.
I don't know if you caught that. He said 18 USC, CFR 795. There's a big difference between the US Code and CFRs. The US Code is statutes. 18 specifically is like the US Criminal Code. So these are things, they're like, hey, you do this, we're going to, put you in jail. We're going to charge you fines. CFRs are like, hey, this is kind of our policy. This is kind of how we want to do things. There's a big, big difference. Remember, this one was the 18 USC 1382. This is the trespass one. Shall be fined under this title or imprisoned more than 6 months. This is 18 USC 795. Shall be fined under this title or imprisoned no more than 1 year or both. These are ramifications for it. You don't see these kind of things under CFRs typically. Like the Indian, the ones that are governing like Indian territories and stuff like that, they have a whole section of criminal laws in them that but they're the criminal laws for the Indian territories. So they're basically replacing what a state law would normally be. So it's a little different. But these apply to everybody. The 18 USC 795 applies to everybody. So let's see how silly this gets.
25. Photographing, sketching defense installations. Whenever the interest of national defense, the president defines certain vital military and naval installations or equipment requiring protection against general dissemination of information. Here is the key word. The president defines. Certain. The president has to define it.
Man, that's just stupid. All right, you even gave a source here for a executive order. This is Executive Order 10104. This one is still valid. It hasn't been superseded by anything. See how this, it supersedes 8381, and 8381 was superseded by 10104. So what 10104 says, therefore, by virtue of authority vested in me, blah, 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 all military, naval, or Air Force installations and equipment which are now classified, designated, or marked under the authority or at the direction of the President, the Secretary of Defense, the Secretary of the Army, the Secretary of the Navy, or the Secretary of the Air Force, as top secret, secret, confidential, or restricted, blah, blah, blah. Hereafter classified, blah, blah, blah. So what the President has done by executive order is he's delegated the ability to mark these things as applying to 795. Now 795 doesn't say secret, top secret, or whatever, but the President in this order has said that this is the criteria. Basically all the classified stuff, top secret, secret, confidential, or restricted, is now what 18 USC 795 applies to. That's the stuff that the President defines. So it's no longer actually what the President defines. It's what the President or the Secretary of Defense, Secretary of the Navy, Secretary of the Air Force, Secretary of the Army, it's what any of them classify, or it's what the people that are under the authority or direction of any of these people classify. So like if some Navy lieutenant classifies something as top secret under the authority of the Secretary of the Navy, it's now illegal to photograph. He's gonna read. I don't.
That means Trump or Obama before him has to sign off saying this.
No, it doesn't mean Trump or Obama before him. It means that anything that is classified under the current president or any previous president, under the current Secretary of Defense or any previous Secretary of Defense,
cannot be done. And as is, that list is very small.
How do you know? How do you know what the list of top secret and confidential and restricted stuff is? You don't have access to it. You don't know what that list is. How do you know how big it is? That's, again, citation needed.
And when it comes down to it, if it's a public base, you can film it.
If it's a public base, you could film it. Well, yeah, sure, except for the portions that are marked as top secret, secret, confidential, or restricted. They're, for example, on a base, like let's say Fort Huachuca or whatever the hell this place is, if they have a rocket test, a top secret rocket testing facility, right? It's top secret. It's located in the middle of their base somewhere. You can't photograph it. Sorry, dude, you can't photograph it. Nobody going into that base for any reason can photograph it. Google satellite images can't photograph it. They would have to submit their satellite images for Google Maps or for Google Earth. They'd have to submit the images to be redacted. Try looking at some of these like top secret bases. Try seeing the middle of them, and you won't. You won't. Sorry. And it's because of this law.
Actually, be proper signage for that to be.
He's reading signage in here. I haven't read any signage in here. He hasn't even finished reading the whole statute. There's no signage in here. Let's go over it. I don't even know if he's going to read it. Whoever, in the interest of national defense, the president defines certain vital military and naval installations or equipment as requiring protection against the general dissemination of information relative thereto, it shall be unlawful to make any photograph, sketch, picture, drawing, map, or graphical representation of such vital military and naval installations or equipment without first obtaining the permission of the commanding officer of the naval or military post, camp, or station. which is different than an installation, or naval vessels, military naval craft, and any separate military or naval command concerned or higher authority, and promptly submitting the product obtained to such commanding officer or higher authority for censorship or such other action as he may deem necessary. Whoever violates the section will be fined under the title or imprisoned, not more than 1 year, both. And then you look at the executive order, and it goes in to clarify all naval, military, or Air Force installations and equipment which are not classified and located within, so they're installations that are located within any military, naval, or Air Force reservation, post, arsenal, proving ground, range, minefield, camp, base, airfield, fort, yard, station, district, or area. Any defensive sea area, yada, yada, yada. Any airspace reservation, any naval harbor, any area required for fleet purposes, any commercial, blah, blah, blah. So the installation wouldn't be the Fort Huachuca or whatever the hell it is. It would be the rocket testing facility inside of it, which I don't know if there is one. So FBI, don't come banging down my door. It's a hypothetical. How about this? It's Arizona, right? So the top secret nuclear sub testing facility there. That would be the installation, and then the fort would be what is containing it. As inept as our government can be from time to time, they don't tend to put top secret, confidential, or restricted installations within easy eyesight of the public. They tend to make it a tad bit more difficult for you to just go and photograph it. Now, there's nothing in here that says that they need to put signs up. I don't know why you're reading it in there. There's nothing in here that says they need to put signs up. You're being ridiculous. Read the words that are on the page. If there is some case that requires signage, then fine. Go ahead and cite it. But until you can do something like that, it's ridiculous to say that they need signage. Now, if you're trying to go for just a general trespass thing, trespassing in general requires notice to the trespasser. The trespasser has to know that he can't be there. Usually that's done via signs, a no trespassing sign. You see that no trespassing sign, you know you're not allowed to be there. If you then enter, you are trespassing. They can prosecute for criminal trespass. This 18 USC 795, it doesn't require that. It just says if you take a photograph of it, you might, oh, that's a pretty submarine, I'm just going to take a photograph of it. You just screwed the pooch. They can get you.
Proper, and to be noted that, hey, you cannot film this. This cannot be recorded or whatever. This
Again, it doesn't say that.
Does not apply to this situation. I have argued this one to death.
It does not apply to the situation, but it doesn't apply to the situation for different reasons than you're trying to make out. It doesn't apply to the situation because the top secret things that the executive order referred to, because it has to be some classified deal, gates, military base gates aren't classified. So this statute refers to classified things now, because that's what the president defined it as. So if it's not classified, then you could take a picture of it. That's why it doesn't apply.
Okay, DS, you're a fucking idiot. Read it again.
Pot, meat, kettle.
I'm not sure where you're getting half that other stuff, because I'm not seeing the citations for it, but the numbers doesn't seem to be adding up right.
Pot, meat, kettle.
Let's see, how is Eli Ritchie? I don't know. Mike Blue Hair is unfortunately not with us. Hit me with a gun due to the fact that he's got medical issues with immediate family. And hopefully he'll be with us this Friday, depending on the situation. Otherwise, it will be another show, and we'll be working on stuff. One can access a list of 795. That is a good question, and I don't even think the list is fully publishable, because
It's not, because it refers to top secret, confidential, and restricted. The government doesn't publish those lists. Sorry, dude.
Betting some of the sites would probably be a blacklist site.
He's betting that some of the sites would be a blacklist site. Oh my.
But they're not supposed to be on the public book.
Not supposed to be on the public book. Oh, good instincts there, BBI.
So you could probably put in a FOIA request asking for all the locations where this is, but it may not be available under it. It might be a fight for that specific issue.
Oh, I think it would be a fight for it.
But as is DS, I have argued this to death. Needs a presidential sign-off in order for that to even be valid. There is no presidential sign-off for every single military gate.
There is no presidential sign-off for any gate that I'm aware of, but there is a presidential sign-off for what this 18 USC section 795 applies to. And you probably should look at it before you pop off about it.
Let's see, we'll continue reading this.
NJ Devil, this is interesting. James said that the road is public all the way up to the gate. That is meaningless. There is no First Amendment law that I'm aware of that says that if something is public, then all of a sudden you have unlimited rights to film on it or to do any other First Amendment activity on it. The test is, I've made videos on this. The test is it a traditional public forum? Traditional public forums would be parks and sidewalks and plazas and things like that. If so, then the government's going to have a real hard time restricting your freedom of speech on it. If it's a limited public forum, then they have to look to see whether the government has made it available or not. That'd be like a school or an auditorium that's owned by the government. If it's a non-public forum, which military bases have been found to be, then you have no rights to do anything if the base has said you can't. It's a non-public forum. They have just about all. It's called rational basis. You go from strict scrutiny, which is the government's probably going to lose. That's in the public forum, down to rational basis, where the government's probably going to win in the non-public forum.
Hey, whenever, okay, yeah, I just showed this. Okay, you read that. Okay, note 1, the DH memo, which mini site does not apply to military installations and has no legal weight regarding the laws of the facility. At best, the memo is an advisory bulletin.
That is absolutely true. The DHS memo has no weight, zero weight, as to the Department of Defense or military bases. And even to the FPS, it is just an advisory bulletin.
Let's see, 2, as is. Okay, that is where you're incorrect, DS. And I have covered this in my quit misusing the DHS. We're going to look this one up. 41 CFR 102-74.420. Whoops.
So he's pulling up this CFR. But this isn't the DHS memo. This is not the DHS memo. Oh, let's see. We're going to go DHS memo. Filming 2010. That looks good. I'm going to do that one. Bada boom, bada bing. There is that. This is the DHS memo. What I always like to point out on it is from the U.S. Department of Homeland Security. Specifically, it is from the Federal Protective Service, which is a sub-agency of the Department of Homeland Security. So it's from the FPS. It is to, this is the dissemination list, it is to the FPS management, FPS law enforcement, and protective security officers. These are the security guards that are hired by the FPS. So it is from the FPS, it is to the FPS. Here's the guidance for FPS law enforcement officers. Here's the guidance for PSOs. Those are the private security guards. Any questions or any incidents, contact the FPS. Further questions regarding the above bulletin, contact the FPS. It's from the FPS, for the FPS, to the FPS by the FPS. Now it does reference 41 CFR 102-74.420. It references that. But the memo is intended as a basically it breaks down that CFR and tells the agents how to interpret it, how to act in compliance with it. And remember what I was saying, the difference between a regulation, a CFR, Code of Federal Regulations, and one of these bad boys, 18 USCs. 18 USCs, these are laws, these are criminal laws. There are consequences for violating this. You look at this, oh my good golly, Miss Molly, there are no consequences for violating it. If you violate this regulation, it's policy. If you violate it, they'll tell you to leave. They will trespass you. And then if you stay, you'll get popped for criminal trespass. It's totally different. It's policy. Policy isn't law, really. I mean, this kind of isn't law. This is telling, like, okay, so we're in section 102-74.420. I'm going to go up one to subpart C. Looky, I got hooky. To whom does this subpart apply? Does it apply to you? Does it apply to me? No, it applies to the GSA. This is the Government Services Agency. They are the people who, that's the agency that owns or leases all the most federal properties. Not DOD kind of properties. Those are owned by or leased by the Department of Defense. But the GSA employs, funnily enough, the GSA employs the Federal Protective Service to provide security for most of their federal properties. So it applies to all property under the authority of the GSA and to all persons entering in or on such property. Each occupant agency shall be responsible for the observance of these rules and regulations. Oh, federal agencies must post the notice in the appendix to this part at each public entrance to each federal facility. It's not really a law in that it's not like a criminal law where there's a legal ramification for violating it. I mean, the FPS could be like, oh, you want to film inside of this federal building? Yeah, sure, go ahead. Couldn't hurt. But by the same token, if you commit criminal trespass, the guard, they're not going to be like, oh, what? Oh, you wanted to come in here to break a law? Yeah, sure, fine. That's cool with us. If you wanted to go in and take a photograph of that top secret nuclear submarine on Fort Huachuca, they're going to pop you for it. So they're different. And this is referenced in the information bulletin. But this is not the information bulletin. They're two totally different things. So you're right, but you're wrong here, Bunny Boots. You're saying that the DHS memo applies. It doesn't. The CFR applies to some things. Sure, it applies to more things than the memo applies to, but it doesn't apply to the Department of Defense.
Accidentally typed that. Okay, we're going to do some schooling here. Guess what that is? What is the policy concerning photographing for news, advertising, or commercial purposes? This is a CFR, just like this CFR.
Just like this CFR, as he flips back and shows a U.S. code. They're different things. Let's see if I can't. We'll do that again.
This is a CFR, just like
this defense installations one is this bad boy. This is not a CFR. You're completely bass backwards on this one, BBI. Completely bass backwards.
this CFR. They're both federal regulations.
No, one is a federal law. It's a criminal law. The other one is a regulation. One applies to. So this one is targeting you. You're the person who takes a picture. This is talking to you. Whenever, in the interest of national defense, he does the thing, then all of a sudden you can't do this. Whoever violates this section shall be fined. This is saying, hey, what's our policy? What's our policy? Oh, hey, yeah, our policy's this. This is our policy. What's store policy to Walmart? Is that law? I don't think so, bro. But it's kind of law because there is a Congress passed some authorizing statutes, but this isn't that.
This is the core portion of the 2010 DHS memo.
It's the core portion of it, but it's not the same thing. Yes, this is the law that the DHS memo was written around. This is the regulation law. It is a law, but there is a distinction to be made there. But there is also distinction to be made between the CFR and the memo that talks about the CFR.
It's taken me 6 months to memorize this, and I suck at memorization, just to let you guys know. Yeah, I hope he's going to do better. He's been up all night. He popped in here a little bit earlier. When this goes to archive, you'll be able to listen to it, backtrack on. In fact, you can probably backtrack it on my channel. I'm not sure if Mike's got that set up on his. As is, yeah, they do owe him damages. As I said, there's a civil case.
I don't know who owes somebody damages. There's a civil case? Did I miss something? I think I missed something.
Yes, and I suck at memorization, just to let you guys know. Yeah, I hope he's going to do better. He's been up all night. He popped in here a little bit earlier. When this goes to archive, you'll be able to listen to it, backtrack on. In fact, you can probably backtrack it on my channel. I'm not sure if Mike's got that set up on his. As is, yeah, they do owe him damages. As I said,
they do owe him damages. If he's talking about Freeman, I don't know who. I'm looking at this. I've not online found nothing either. They won't be lying to a federal judge. They should owe James money for kidnapping James. If that's what he's referring to, Bunny Boots. I don't know where you're getting this, man. That's a pretty bold claim to make that the federal government owes James damages. I would love to see your theory of recovery on that.
There's a civil case for that. Now, bringing a civil case is going to be a whole different test. So that is where you're again wrong. DHS memo does hold weight, but it's not because of the memo itself. It's because of the cited CFR on.
The DHS memo doesn't hold weight. The CFR also doesn't hold weight because it doesn't apply to the Department of Defense. So I showed you that it applies to the GSA, and the GSA is a separate and distinct agency from the Department of Defense. What about this one? Delegation of authority. What is the delegation of authority? Again, it's talking about the GSA. So even up in subchapter C, we're talking subtitle C, general provisions. Federal Register, miscellaneous agencies. That's not it. Let's see if there's grants and agreements. I don't know if I'm going to find anything on it. Oh Lord, federal elections. I don't see Here we go. National Defense. Department of Defense. We're in 32 CFR. What? That's entirely different. These regulations are an entirely different subtitle. Entirely different. Because we went from 41 CFR. Department of Defense is in 32 CFR. I don't think it applies, buddy boots.
On the bottom of the first page, read it again.
Yeah, read it again. But you got to remember, like, these things are organized. The way they're organized, Title 41 is Public Contracts and Property Management. Public Contracts and Property Management. It's for the Federal Property Management Regulation System. Oh, look at that. Federal proper. Oh, what are these? Defense Material System. Public Buildings and Space. Look at that. Oh, Acquisition of Real Property. Federal Buildings Fund. All these. This 41 CFR. This 41 CFR has nothing to do with the Department of Defense. Nothing to do with it. You got to remember the way our government works. Like the Department of Justice, the DOJ, is an entirely different department than the Department of Defense. It has entirely different funding. It has entirely different management structures, different goals. Everything's different. So something like the Department of Homeland Security does not tell the Department of Defense what to do. They're two different departments. It would be like, I don't know, at Walmart it would be like the manager of the electronics department trying to tell the manager of the sporting goods department what to do. They're two separate departments. So you can't say that just because you found a statute that it works. It has to be a statute directed at the right group of people. And it's the Federal Property Management System, and it is Federal Management Regulation, Real Property, Facility Management, Conduct on Federal Property, who does it apply to? GSA. This is for the GSA. It's not for the Department of Defense.
Let's see here. As of 2011, all military installations have some sort of classification stated within the renewal, reaffirmed Presidential Order 1104. Be advised that there are many other non-military installation facilities covered within such an order of aircraft manufacturing plants. That is incorrect. Otherwise, this would have been cited and used against us several.
Maybe I missed that. We're going to go back over that again a little bit.
That is where you're again wrong. DHS memo does hold weight, but it's not because of the memo itself. It's because of the cited CFR on the bottom of the first page. Read it again. Let's see here. As of 2011, all military installations have some sort of classification stated within the renewal, reaffirmed Presidential Order 11.
All military installations have some sort of classification as stated within the renewal, reaffirmed of Presidential Order 10104. Yeah, military installations. So, okay, that's fine. That's cool. We go back to 10104. It's the whole all military, naval, or Air Force installations, which are now classified, designated, or marked under the authority or direction of the President, etc., as top secret, secret, confidential, or restricted, and located within any military, naval, or Air Force reservation, post, or arsenal. So the installation, he's like, this guy like didn't understand what he was reading. That's why he thinks a military installation is the same thing as a military base. Non-military installations and facilities also covered within this order, such as Air Force or aircraft manufacturing plants and nuclear plants. Again, it would be the things on the inside. It would be the parts inside that are marked top secret, secret, etc. A list is available of disclosed locations from the DoD upon letter request with your original signature. Maybe.
104. Be advised that there are many other non-military installation facilities covered within such an order of aircraft manufacturing plants. That is incorrect. Otherwise, this would have...
It is correct, and it's also misleading and wrong at the same time.
Been cited and used against us several times. And as is presidential orders usually need to be reaffirmed each year.
Cite your source. I know of nothing that says a presidential order needs to be reaffirmed each year. How would you... So the authority of the president to make an executive order is from the Constitution. He has the power to execute the laws of the land, and that's how executive orders kind of come into play, as opposed to executive agreements, which are based off the treaty kind of thing. But they both have weight. They both have more weight than like a state law. They are outclassed by statutes and treaties, federal statutes and treaties. But Congress can't say that the president has to reaffirm his orders every year or anything like that. And if Congress can't say it, that means that the only other way that could be put into place is if there's some constitutional basis for it. There is nothing written in the Constitution. I have never seen any Supreme Court case that has stated that the president has to reaffirm his presidential orders, his executive agreements every year. So cite your source, dude. Let's
get a quick overview. What is presidential order? What is in this one? Defining certain vital military naval installations. Okay, case where section vested in me by foregoing statutory provisions and interest in national defense, I hereby define the following vital... It's too... No. This is too broad. It wouldn't hold up in court.
The problem that he's running into on this one is he's trying to read too fast. He's trying to find a reason to negate it quickly. And the too broad assertion has been made in First Amendment cases, which is probably why it comes to mind. But he doesn't understand what makes something too broad. Under the strict scrutiny analysis for a First Amendment test, and remember, strict scrutiny would take place like if the government was trying to restrict your ability to speak in a public forum, then the strict scrutiny analysis is it has to be the least restrictive, narrowly tailored. It has to directly relate to a legitimate government purpose, but it's that narrowly tailored kind of thing. For example, maybe the government can't say no amplified devices for audio, for speaking, because maybe their legitimate government purpose is they want to keep the volume down so they're not disturbing businesses, right? That's the legitimate government purpose. And you could challenge that by saying it's overbroad, because one of those people who've been like smoking all their lives and they've got to speak with the voice recorder thing. That's an amplified audio device. All of a sudden, that's going to be an issue. They say no, this is overbroad. What you're trying to do is you're trying to limit the decibels. So a narrowly tailored approach would be no amplified devices that project sound at any volume greater than X number of decibels. So that's what they're looking at. They're looking for something narrowly tailored. Now this isn't that, because this is narrowly tailored. You have to go back to the beginning. The president defines certain vital military and naval installations or equipment as requiring protection. So the president defines it. So the president gets to make an executive order as to how he defines it. And he defines it very very narrowly. It's anything that is top secret, secret, confidential, or restricted. It's narrowly tailored on this in that they are classified. It's only the classified things that you can't photograph. That's very narrowly tailored. They're not saying you can't take pictures of any military base. You can't take pictures of any military vehicle. They're saying you can't take pictures. They have a legitimate interest. We need to protect our top secret or classified military secrets. Right? That's a legitimate government interest. The most narrowly tailored way they could do that is to say you can't take pictures of those things that are specifically top secret, confidential, or restricted. That's about as narrowly tailored as you can get. So whatever you're banging on about it being too broad, you just don't understand what you're talking about. You literally don't understand why a court would say that a First Amendment related regulation or rule is too broad. You literally don't understand the meaning, the legal meaning of the words the courts are using.
All naval installations now which are classified, designated, are marked under the authority of our direction of President. Yeah, if this is real right here, this was 1950.
What is your point? Just because it's 1950 doesn't mean that it's no longer valid. There are, believe it or not, there are laws on the books. There are executive orders on the books that are much older than that.
No! This has to be re-updated. No.
Why does it have to be re-updated? Where are you getting this? Citation needed. What gives you the grounds to say that? Your gut? Yeah. You need to rethink this whole thing, man. You're setting out, you want to believe that X is true, and anything that says X isn't true, you're just rejecting, and you're just grabbing the very first thing that comes to mind to reject it. It's ridiculous. I can't believe that people are actually believing this nonsense and they're not calling you out on it. It's ridiculous.
Oh yeah, this is way too freaking old, man.
Yeah, how old can it be, Bunny Boots? How old can it be? Where in the Constitution does it say how old an executive order can be before it has to be reaffirmed? Explain that to me. What Supreme Court case states how old an executive order can be before it has to be reaffirmed? Please enlighten me. I would love to know, because that's what you have just said, the most retarded thing I have ever heard. No, that's hyperbole. I have heard way more retarded things than that.
Going into the Korean War with this one. We're in the middle of the Cold War. Yeah, this doesn't work, buddy. No.
It doesn't work because Mafeels, the classic Mafeels legal defense.
As is, presidential orders have to be reaffirmed after so much time. They
Yeah, how much time? And where are you getting this information?
do expire.
They do expire, he says. He says, if I state it like I mean it, then it'll be true.
Let's see, a list of available investigations, so-called auditors. Let's see, 3. Recently, the IRS has joined an investigation called Auditors, and money received and even donations must be reported. If not, they could also...
The rest of it, I've lost a lot of my desire to go further with this. He does go on to say that executive orders are unconstitutional or something like that. This executive order was never overturned. You would see some notes related on it where it had been overturned, I'm assuming, or classified. President Trump just recently was doing the whole travel ban executive orders. If executive orders were just all executive orders were unconstitutional, why would they go through all the trouble of trying to make the claims that it was, a violation of people's constitutional rights? Why wouldn't they just say that no, there's executive orders are just by their nature unconstitutional? They didn't do that. guess why they didn't do that? I mean, the Supreme Court, Reagan did one. Actually, Carter did it, and then Reagan. I forget what it was, but it was the Iran one, where Reagan froze Iranian assets, and they sued. And the Supreme Court, it went all the way to the Supreme Court, and the Supreme Court was totally cool with executive orders. And they've been cool with executive agreements. There's several cases on executive agreements out there, which are the trade-based ones. So yeah, it's unless something new has happened since I got out of law school, and because I honestly I don't mess around with executive orders. Law school was a long time ago, but the Reagan one was like 81, and I know there was one in like 2004. Oh, let's see. Executive order. Supremacy clause. Supreme Court. Let's try that. That looks right. 2003. That's the one. It's the Holocaust one. Yeah. The Holocaust one. Let's see. Do we have... Where's the dumb decision at? Syllabus. Can you see the syllabus? No, it's government, blah, blah, blah. Meanwhile, California. Federal government informed California that would damage the IH. That's it. That's it. The IH, lots of letters, one. That is a... Here we go. International Commission on Holocaust Era Insurance Claims. Federal Foreign Affairs Power. There is executive authority to decide what the policy should be. Yep. So yeah, this was just fairly recently. This was a case where there was an executive order, and the court looked at it and they're like, yeah, the executive branch, there's no question that at some point an exercise of state power that touches on foreign relations must yield to the national government's policy, or that generally there is an executive authority to decide what that policy should be. There is no question, they said, there's no question that at some point there is an executive authority to decide what that policy should be. In foreign policy, the president, not Congress, has the lead role. So executive agreements, executive orders, the courts have looked at them. They're good. Well, I mean, like, they're in and of themselves, they're constitutional. The underlying kind of what they're dealing with may or may not be. But that's it. I've rambled on way more than long enough. This has got to be like 2 hours at this point or something stupid. Anyway, have a good night. Bunny Boots. I I hope you don't take this the wrong way, but just like learn about the law before you start making legal claims. Because I don't know if you notice this, but on this stream there was a whole ton of people who, I mean, this is at 1,208 views. You're misleading a lot of people. You're miseducating a lot of people. If you want to be a lawyer, at some point in time, people are going to look back on this and they're going to be like, man, this guy spread a whole bunch of nonsense to a whole bunch of people. I don't know if I want somebody who's just going to like have a gut instinct and going to make a statement that the law is X. Because doing that kind of thing, if you do want to practice law, that'll get you into a whole bunch of trouble. That's malpractice claims and all sorts of disciplinary actions and things like that. You can't just make up the law. You'll lose the case for your client. You could get, sued yourself. It's just not good. And you don't want to put that precedent out there. You don't want to mislead 1,000 plus people. You just don't want to do it. So I hope you take this the right way. You take it as a learning experience, and have a great day. And please keep doing audits, and maybe stop giving legal advice.